but secure the removal of the Deputy Chief Justice. And that predominant purpose has a collateral attack on the entire judiciary. That's why you're seeing so many senior counsels here today. So that we are going to demonstrate that these proceedings are not necessarily a prosecution against.
All right, this means that it needs to come to an end. KTN News Center comes to an end right now. My name is Brenda Zederadido, and I live in the safe hands of my colleague Lofty Mitambo, who's coming up next with Law Mashinani. But before he gets into the set, he's already in studio, but before he gets into the set, I'd like to leave you with the live coverage of what's happening at the Milimani Law Courts, where the live proceeding of the case, graft case against Deputy Chief Justice Philomena Mwilu is currently underway. Enjoy the rest of your viewing.
Under which we want to address you and to seek then directions from you that you cannot proceed with this matter in view of the objections that we are raising. That on the face of it, looking at the charges, this is not a criminal prosecution, and when the evidence will be put before the appropriate forum, it will emerge that a contractual transaction, a purely commercial transaction, has been criminalized. And it's a transaction that took place more than nearly 5 years ago. So it is like a nuclear bomb. This is a nuclear option to look for any material that will be used to drag the Deputy Chief Justice into this trial. Thirdly, we are going to demonstrate that there is no factual foundation. There is no factual foundation for instituting these charges against the Deputy Chief Justice. Fourthly, we are going to demonstrate that these proceedings are an abuse of the process of the court, and that matters which naturally fall within the province of the Ethics and Anti-Corruption Commission, and every case, including the ones you have dealt with, were investigated and the recommendations given for prosecution by the Ethics and Anti-Corruption Commission on the face of the charge sheet, although these are corruption-related offenses under the Anti-Corruption Act. This charges has been brought by the police, and we are going to demonstrate why the Director of Public Prosecution on this matter chose to use the Director of Criminal Investigations, who turned out to be user-friendly, as opposed to using the legal regime, the statutory regime that relates to offenses created under the Anti-Corruption Act, and for the purpose for which this court has been established as an Anti-Corruption Act. Otherwise, for normal penal code cases, we would have gone before court number one. Finally, amongst other reasons which probably we may not need to advance for purposes of persuading Your Honor that this matter should not be taken, a plea should not be taken, is that despite the fact that this matters, the action complained of in the charge sheets took place nearly 5 years ago, in a space of 5 hours yesterday, both accused, the first accused was arrested. Taken to the Director of Criminal Investigations. And by 5 o'clock, 5:30 I think, we are before Your Lordship, Your Honor. That is an unusual efficiency. Very unusual. For those of us who practice in this court. Now, Your Honor, I want to persuade you that you should not be in a hurry. To require the accused person to take plea. And by that, I'm guided by the authority of a judge of the High Court, Justice Nyakundi. I'll give you a copy. My Lord, in my reading of the law in relation to taking of pleas, there is a case that is familiar to this court, Adan versus the Republic. I think there is no case that advanced the need and the process of a careful consideration of a plea, more than Adan versus the Republic. During the phase in which Kenya faced a lot of political headwinds, and people were being arrested and kept in custody for more than 60 days, brought to court at night and forced to take a plea in order to address that mischief. The Court of Appeal came with another very important issue, the case of Odhiambo Olen versus the Republic. And in that case, the Court of Appeal pointed out that at the time of the plea taking, the court has a responsibility. It's not a matter that should be left to an accused person. It's not a matter to be left to the advocates, but the courts also have a responsibility. My Lord, Your Honor, it may have been thought that we are better persons and more obedient to the rule of law and respectful the Bill of Rights, so that we had a case like Adan versus the Republic. But even during the colonial period, there was another case, Tambukiza versus Unyonga. This is before independence. A decision of the Supreme Court of Kenya, which later on became the Court of Appeal. In 1958, this is what this court is saying, holding number 2, if I may invite your honor to look at holding number 2. The whole object of Section 89 of the Criminal Procedure Code and of the subsequent sections dealing with the framing of charges is that before a trial can be held, the accused must be arraigned before the court on a formal charge which must comply with the provisions of the Criminal Procedure Code. If there is no charge, then there is nothing in which there can be an error, omission, or irregularity. What the court is saying, that you must be satisfied that there is a charge. And in fact, it is for this provision section 89, subsection 9, you would then be required to admit the charge. The court is required to admit the charge after consideration of the charge. So, Your Honor, in relation to now the authority that I've placed before you, and I'm looking at page 6. Page 6.
Which one, the one of Tumbukiza or the one of...
The one I gave you.
Na mtazamaji, karibu katika matangazo yetu kwa lugha ya Kiswahili kwenye Leo Mashinani. Huyo akiwa ni wakili James Orengo akiongoza jopo la mawakili ambao wanamwakilisha Bi Philomena Mwilu, kunradhi, naibu jaji mkuu ambaye alikamatwa hapo jana kuachiliwa kwa dhamana, tena baadaye kufikishwa mahakamani siku ya leo. Hapa katika Leo Mashinani tutakuwa tunatupa jicho letu na masikio kule Ange kuweza kuifuatilia kesi ile kwa ajili yako, ambapo Bi Philomena Mwilu anashtakiwa na makosa ya wizi, kukosa kulipa kodi pamoja na matumizi mabaya ya afisi, ikiwa ni kesi moja kubwa zaidi chini ya uongozi wake Nurdin Haji, kiongozi wa mashtaka ya umma kuwahi kufanyika nchini Kenya, kukamatwa kwa naibu jaji mkuu. Mtazamaji, usondoke, tulia hapo hapo, nitakuwa nawe hadi mida ya saa 7. Jina langu ni Lofty Matambo, ni kuregeshe mahakamani.
As evidence and looking at the charge, an accused person can then make an informed decision as to whether to plead guilty or not to plead guilty. Your Honor, I want to persuade you that this procedure has very long history. In England, before the Magna Carta, there emerged a mechanism which found itself in common law jurisdictions, including our own jurisdiction, the idea of having a pre-trial process so that before you take an accused person to court, there is a determination as whether there is a proper charge and there is sufficiency of evidence. Not sufficient for determination of guilt or innocence,